Good afternoon. This legislative hearing on H.R. 569, H.R. 570, H.R. 602, H.R. 671, H.R. 679, H.R. 733, H.R. 894, and H.R. 1405 will now come to order. Today we have a large number of witnesses present due to the high level of interest in some of the bills before us. Therefore, in the interest of time, I'm going to forego any lengthy opening statement and just briefly touch on three of the bills on the agenda today that that I'm proud to introduce. First off, we have H.R. 569, the Veterans Compensation Cost of Living Act, or COLA, of 2013, provides a costing limit adjustment increase to veterans' disability compensation rates and other benefits. Also, H.R. 570, the American Heroes COLA Act, which is related to the former H.R. 569 COLA Act of 2013, except this bill seeks to make permanent the annual increase to veterans' disability compensation rates and other benefits by tying the increase to the cost of living adjustment for Social Security benefits. With the passage of the American Heroes COLA Act, veterans will never again have to depend on congressional action to receive an increase in their cost of living adjustments they have more than earned throughout their service. Instead, this increase will become automatic from year to year, just as Social Security benefits increase and are adjusted automatically every year. As some of you may recall, last year, our annual COLA bill was held up in the Senate with reports that had been put on a secret hold by a senator. There are some questions to whether this bill would pass and if veterans would see their annual COLA in a timely manner. This situation was unacceptable and unfair to veterans, and thankfully, with pressure from this committee and the veterans community, it was ultimately passed and signed into law. And I can tell you it was really close to the end of the year. It was November 27th, which I know for a fact because it happens to be my birthday. So, however, the final bill that I have here today that I've sponsored is H.R. 733, along with my good friend Congressman Walz, the Access to Veterans Benefits Improvement Act, which provides certain local government employees and certain employees of Congress to access to case tracking information through the Department of Veterans Affairs. There is no doubt that we have a responsibility to serve our veterans by ensuring that every effort is made to simplify the claims process. Key actors in this effort are county veteran service officers whose expertise in claim development benefits veterans in many communities across America. Their assistance is especially critical to many thousands of veterans who live in rural areas hours away from a VA regional office. Many veterans are overwhelmed as they try to navigate their way through the claims process, and they are also further frustrated when they ask for help from their county VSO or their member of Congress, and that person cannot directly access even the most basic information about the status of their claim. This bill would allow these local government officials to check on the status of the veteran's claim and ensure that VA has all of the information needed to process claims in the most efficient manner possible. Again, in the interest of time, I'd reiterate my request that today's witness abide by the decorum of the rules to this hearing. To summarize your statement to 5 minutes or less during the oral testimony. We have a large number of individuals ready to testify in the legislation today. I want to make sure everyone is heard in a timely manner. I want to also remind that all present, without objection, your written testimony will be made part of the hearing record. I appreciate everyone's attendance at this hearing, and now call on the ranking member, Ms. Titus, for her opening statement.
Thank you, Mr. Chairman. I do realize we have a full schedule, and I'll keep my remarks brief as well, but I think it's important that we thank our colleagues for the good work that they've done on these various bills and point out that they address some of the unique needs of our nation's veterans. The bills that are before us today are a variety of issues. They range from military sexual assault, recognizing Guard and Reserve members, increasing compensation, and improving the appeals process, things that we have heard a lot about in testimony before this committee. I'm also pleased to say that I'm proud that I worked with the chairman to introduce the disability compensation COLA bills, which are H.R. 569 and 570. Another bill on the agenda, H.R. 671, the Ruth Moore Act of 2013, that's introduced by Ms. Pingree. I'm very pleased to see that here today because we have heard some very compelling statistics about the women who are in our military and some of the problems that they face personally and also professionally as a result of this, and how difficult sometimes it is to receive assistance and compensation and counseling and the things that they need. HR 671 will address some of these. Also, HR 679, Mr. Walls's bill to honor the Guard reserves when they retire and they've been in that service their entire careers, just maybe not have been in the field, certainly should be recognized, and I support that. Your other bill, Mr. Chairman, H.R. 733, Access to Veterans Benefits Improvement Act, would grant county officers and other state employees access to some records. We want to protect the privacy of our veterans, but we certainly need to expedite the process in helping them get compensation and remove the backlog as quickly as possible. I know in my district office, as we try to help veterans, this is often a problem, and I think your bill will go a long way to addressing that. There are other bills that are before us today which target the appeals process. I'm anxious to hear from our colleagues on these, and again, appreciate your thoughtful work. I yield back.
Thank the gentlelady, and I know pleasure to have the chairman of the full committee and the ranking member of the full committee here, and I know Chairman Miller would also like to make a opening statement. So, Chairman, you're recognized.
Thank you very much. With your permission, I want to make a few remarks on H.R. 602, the Veterans Second Amendment Protection Act, and that's a bill that I introduced to protect the constitutional rights of our veterans.
Without objection.
And this piece of legislation would end an arbitrary process through which veterans are required to go through at the Department of Veterans Affairs, where they actually strip certain veterans and other beneficiaries of their Second Amendment constitutional rights. Under current practice, veterans who have a fiduciary appointed to manage their affairs are deemed to be mentally defective. And as a result, these veterans are reported to the FBI's National Instant Criminal Background Check, or the NICS system, a system which prevents individuals from purchasing firearms in the United States and criminalizes the possession of a firearm. I label this process arbitrary because, pursuant to VA Regulation 38 CFR Section 3.353, the definition of mental incompetency is one who, because of injury or disease, lacks the mental capacity to contract or to manage his or her own affairs, including disbursement of funds without limitation. In plain English, this means that if VA determines that a person cannot manage their finances and needs a fiduciary, their Second Amendment rights are automatically taken away. This really makes no sense. As a reminder, a majority of VA's regulations concerning fiduciary matters are from 1975. Although in the course of this committee's oversight, VA has indicated that it will update these regulations, to date, no new fiduciary regulations have been promulgated. In previous discussions with VA, I have emphasized that its regulatory scheme does not take into account the importance that our judicial system plays in determining when someone's constitutional rights should be infringed upon. I would again encourage VA to update its regulations accordingly. And as a reminder, the Department itself was opposed to judicial review of any kind on VA determinations all the way through 1988. Judicial proceedings are comprehensive, and all interested parties have a right to be represented and heard during them. This is a far cry from the process during which VA rating specialists determine that a veteran is mentally defective. Accordingly, the Veterans Second Amendment Protection Act would require that a judicial authority, rather than an internal VA decision maker, make the determination that a veteran poses a danger to themselves or others prior to their name being sent to the NICS. Taking away a constitutional right is a serious action, and one that should not be taken lightly, particularly when it concerns our nation's veterans. Affording veterans their due process rights under the law in any and all contexts is of utmost importance to me and I think most members of the committee. As will be further discussed during this hearing, there are other issues with VA's fiduciary program that also affect veterans' due process rights, and I'll defer to the witnesses that have been called here today to testify as to the specifics of the fiduciary program as a whole for further comment. Mr. Chairman, thank you to you and the members of the subcommittee for your time, and I want to encourage all of you to support H.R. 602, the Veterans Second Amendment Protection Act, and with that I yield back.
Thank the chairman. And with that, the chair will recognize the ranking member of the full committee, Mr. Michaud, for a statement.
Thank you very much, Mr. Chairman and Madam Ranking Member, for having this hearing. It's good to see the chairman of the full committee. We're on the bookends now. Glad to see him here as well. And I'd like to thank Congresswoman Pingree for being here today to testify. My colleague from Maine introduced the Ruth Moore Act to help victims of military sexual assault get help that they need, and I'm proud to be a co-sponsor of that legislation. I'd also like to welcome Ruth Moore from Millbridge, Maine. She is my constituent and the bill's namesake. Ruth, I know it takes a lot to stand up and fight for the rights. I want to thank you for your continued advocacy of this very, very critical issue. Sadly, sexual assaults in the military continues to be a problem for too many who are serving our great nation. Our nation must do more to address it, and I look forward to hearing Congresswoman Pingree's testimony today. The Ruth Moore Act is about making sure that victims of military sexual trauma gets a fair shake and are not further victimized by the bureaucracy, something that I'm confident that this committee can deal with as we move forward to look at this legislation. I look forward to the Congresswoman testimony, and I want to thank you very much, Mr. Chairman, for having this very important hearing on the several bills that we're hearing today. And with that, I yield back to balance my time.
Thank the ranking member for that. And at this time, I'd like to welcome my colleagues in the House that are currently sitting at the witness table. First, we'll hear from the gentlelady from Maine, Ms. Pingree, who is sponsoring H.R. 671. Then we'll hear from the gentleman from Ohio, Mr. Johnson, who is sponsoring H.R. 894. And finally, we'll hear from the gentleman from Minnesota, Mr. Walls, who is sponsoring H.R. 679. I'd like to welcome you all to this legislative hearing. Your complete and written statements will be entered into the hearing record. And with that, Congresswoman Pingree, we'll start with you, and you are now recognized for 5 minutes.
Great. Well, thank you very much, Chairman Runyon. Thank you to you and Ranking Member Titus. I also want to thank Ranking Member Michaud for his very kind introduction. We are very proud of the work that Mike does back at home in Maine for all of our veterans and in the work that he does on this committee, and I'm honored to serve with him. There are only 2 of us in Maine, so we have to cover a lot of territory. And thank you to Chairman Miller for being here today, and thank you for your great advocacy for veterans and your leadership on the Veterans Affairs Committee. I appreciate your presence here and the work that you do. I'm very grateful that you're considering the Ruth Moore Act in this afternoon's legislative hearing, and I appreciate the opportunity just to talk a little bit more about this bill and why I desperately think it needs to become a law. The bill has been endorsed by every major VSO, including the American Legion and the Veterans of Foreign Wars. We appreciate their support and all the work that they do for veterans and their families. The Ruth Moore Act would relax the evidentiary standards for survivors of military sexual trauma who file claims for mental health conditions with the VA. Currently, MST survivors need further proof of the assault, which for many of them is impossible. Under this bill, in order to receive service-connected benefits, a veteran would need a statement that the assault took place, along with a diagnosis from a VA healthcare professional that links the assault to a mental condition. This bill also requires the VA to report MST-related claims information back to Congress. As members of Congress, we have a responsibility to ensure that the VA is providing timely and accurate decisions to veterans, but we can't do that without sufficient data. The bill is closely modeled after the 2010 change to VA regulations for combat veterans who have filed PTSD claims based on their military service. As I'm sure most of you know, the VA relaxed the evidentiary standards for veterans who suffer from combat-related PTSD. The VA finally acknowledged that far too many veterans who have deployed into harm's way suffered from service-related PTSD, but could not, through no fault of their own, locate military documentation that verified the traumatic events that triggered their PTSD. The VA now accepts their statement of traumatic events, along with a PTSD diagnosis and a medical link, as enough to receive disability benefits. So what we have is an inequity in the system, and those who were raped or harassed in the military have a much harder path to receiving benefits, even though injuries are service-connected and the same standards should apply. Ruth Moore, who Mike introduced earlier, who's here with her husband Butch and her daughter Samantha, is who this bill is named for. She is a U.S. Navy veteran from Maine who was raped twice during her military service. When she reported it, she was discharged and labeled as having a personality disorder. She spent 23 years fighting the VA to get benefits, and she battled homelessness and PTSD during that time. I am very proud of Ruth to be here with us today with her willingness to come forward and to help so many others in her own testimony, both before this committee and with the many people she's been willing to talk to about her story. Ruth, like many MST survivors, did not have the military records that corroborated the rape, so her claim was repeatedly denied. And unfortunately, she's not alone. DOD's own numbers indicate that over 85% of assaults go unreported. So I ask you, how are these veterans supposed to qualify for the help they need from the VA? The VA will tell you that the system accepts secondary markers as evidence to verify that these assaults occurred. And as comforting as that sounds, we have seen time and time again that the VA is inconsistent in applying those standards. What one regional office will accept as proof, another will deny. Almost every day, I hear from another survivor who has had their claim denied after these secondary markers were ignored. So I think it's a problem of fundamental fairness. If a medical diagnosis and link to a claimed event is enough for one group of veterans, it ought to be enough for another, especially when we know how hard it is for documentation to exist to support both instances of sexual assault or combat-related events. Critics of this bill might say that it's too easy and veterans can just say anything to get those benefits. First of all, that's just simply not true. There still needs to be a medical diagnosis and a medical link, which are not at all easy to come by. And secondly, we hear that the same argument when the VA proposed similar changes for combat veterans, and I haven't heard the VA say there were big problems with veterans lying about their service. The bottom line is that it's gone on for too long, and the burden of proof has been on the veteran, and it needs to change now. Mr. Chair, over the last 2 years, I have heard from dozens and dozens of veterans from all over the country. Men and women who volunteered to serve, many of them planning on a career in the military, only to have their career cut short by the horror of a violent sexual assault. Whether the attack happened on a Navy base in Europe or a National Guard training facility here in the U.S., whether they were soldiers, sailors, airmen, Marines, the story too often has the same ending. The victims were blamed, the crime was covered up, and the survivors themselves become the subject of further harassment and recrimination. All too often what followed was years of mental health issues, lost jobs, substance abuse, and homelessness. But the stories don't have to end this way. With the Ruth Moore Act, we can change the VA's policy so that veterans who survive a sexual assault can at least get the benefits they deserve. Thank you very much for your time, and thank you for considering this bill.
Thank you, Congresswoman Pingree. With that, we'll recognize Congressman Johnson. You are now recognized for 5 minutes for your oral statement.
Chairman Runyon, Ranking Member Titus, and members of the subcommittee, I appreciate the opportunity to testify before you on H.R. 894. This is important legislation I introduced to reform the Department of Veterans Affairs fiduciary program. As most of you know, last Congress I served as the Oversight and Investigation Subcommittee Chairman on the House Veterans Affairs Committee. An investigation into the VA's fiduciary program by my subcommittee revealed shocking behavior on the part of the VA's hired fiduciaries and gross misfeasance on the part of the VA. Some fiduciaries entrusted to manage the finances of our nation's heroes who are unable to do so themselves were caught abusing the system by withholding funds, embezzling veterans' money, and other egregious actions. Furthermore, an Oversight and Investigation Subcommittee hearing held on February 9th of last year uncovered the fact that many of the VA's fiduciary program policies do not correspond with actual practices. For instance, the VA claims to have a policy stating preference for family members and friends to serve as a veteran's fiduciary. However, the investigation into the fiduciary program revealed instances where this is not the case. In one instance, the VA arbitrarily removed a veteran's wife who served as her husband's fiduciary for 10 years and replaced her with a paid fiduciary. There were also many honest and hardworking fiduciaries that experienced difficulty performing their duties due to the bureaucratic nature of the VA's fiduciary program. We owe it to America's heroes to provide them with a fiduciary program that is more responsive to the needs of the veterans it is supposed to serve. For these reasons, I'm proud to sponsor H.R. 894, the Veterans Fiduciary Reform Act. This important legislation initially introduced last Congress is based on problems uncovered before, during, and after the hearing, as well as valuable input from veteran services organizations and individuals who have experienced difficulties with the program firsthand. It is designed to transform the VA's fiduciary program to better serve the needs of our most vulnerable veterans and their hardworking fiduciaries. And most importantly, it will protect veterans in the program from falling victim to deceitful and criminal fiduciaries. Specifically, the Veterans Fiduciary Reform Act would require a credit and criminal background check each time a fiduciary is appointed, and allow veterans to petition to have their fiduciary removed if problems arise. It would also decrease the potential maximum fee a fiduciary can receive to the lesser of 3% or $35 per month, similar to Social Security's fiduciary program. This will help discourage those who enroll as VA fiduciaries with only a profit motive in mind. Importantly, H.R. 894 would enable veterans to appeal their incompetent status at any time, a right currently not granted to veterans. Additionally, it would allow veterans to name a preferred fiduciary, such as a family member. Last year, my subcommittee heard numerous complaints about the requirement for fiduciaries to obtain a bond. While proper in some settings, it is inappropriate when it causes unnecessary hardship, such as a mother caring for her veteran son. This legislation would require the VA to consider whether a bond is necessary and if it will adversely affect the fiduciary and the veterans he or she serves. H.R. 894 would also direct the VA's undersecretaries for health and benefits to coordinate their efforts to ensure that fiduciaries caring for their loved ones are not overly burdened by redundant requirements. Lastly, this bill aims to simplify annual reporting requirements. Currently, the VA does not have to review a fiduciary's annual accounting, and when it does, it places an onerous burden on those fiduciaries who are serving out of love, not of monetary gain. This bill will implement a straightforward annual accounting requirement and gives the VA the opportunity to audit fiduciaries whose accounting is suspect. These significant changes would strengthen the VA standards for administering the fiduciary program and increase protection for vulnerable veterans. Requiring background checks and lowering the fee as a fiduciary requiring background checks and lowering the fee a fiduciary can charge would also increase scrutiny of potential fiduciaries and help root out potential predators. This legislation also adds a layer of protection for veterans with fiduciaries by incorporating the ability for veterans to petition to have their fiduciary removed and replaced. I am proud that last Congress, the Veterans Fiduciary Act of 2012 passed the House Veterans Affairs Committee unopposed and passed the full House by voice vote on September 19, 2012. Unfortunately, this important legislation was not considered by the Senate, and therefore the VA's fiduciary program is still in urgent need of reform. Chairman Runyon, Ranking Member Titus, thank you again for the opportunity to speak on this important legislation, H.R. 894. I'm hopeful that this legislation will again be favorably considered by the Veterans Affairs Committee and this time become law. Our veterans are willing to sacrifice everything to serve our nation, and they deserve to receive the care, the benefits, and the respect they've earned. With that, I yield back, sir.
Thank you, Congressman Johnson. With that, recognize Congressman Walls for his testimony.
Well, thank you, Chairman Runyon and Ranking Member Titus, for your commitment to our veterans, and to our full committee, Chairman and Ranking Member. I may be somewhat biased, but I'm incredibly proud of this committee and the work you've done, and I would extend that to an incredible staff on the majority and minority side of making sure they're working to our veterans. So thank you for bringing up H.R. 679 to give us the opportunity to present it. Honor America's Guard and Reserve Retiree Act. This is one of those rare, very simple bills. First and foremost, it costs nothing, but it extends
respect and honor to our veterans is something that they will not ask for, but they have certainly earned. This is a case of a guardsman or woman can serve 20 years in uniform, by the way, meeting every standard of their active duty counterparts, from enlistment standards to physical fitness to weapons proficiency to their professional training. In some cases, those can be months long, and they are, in many cases, after 20 years, they are the most senior people responsible for the training of our warriors. But if they were never called to active duty Title 10 for other than training for more than 179 days, we reward them with all of the benefits they've earned, financial benefits. This bill is not about financial benefits. It's about what I consider to be a simple oversight that they do not have the legal ability to call themselves veterans of America's armed forces. And it corrects that. It's the right thing to do. It has been vetted in the last two Congresses. The staff and the legal counsel have done a wonderful job of putting up a firewall to make sure this isn't about additional benefits. It's about duty, honor, country, and respect. It has passed the House of Representatives twice unanimously and has stalled in the Senate, and I think since that time we have taken great care to educate our colleagues in the other chamber about what this is about. I ask that we be given the opportunity to bring this up one more time, to do what's right, to allow those folks. Most Americans don't know this is the case, but I think sitting next to Colonel Johnson and others in this room, veterans are very, very particular about getting right of where they served, what devices they wear, and how they're addressed. And getting this wrong for them, having someone who served in uniform for 20 years feel bad about referring to themselves as a veteran is simply wrong, and we can fix that with this bill. So I thank you all. Thank you, Chairman Runyon, for being an early supporter of this bill and give the opportunity. I'd also like to add one more word of support for the chairman's H.R. 733, the Access to Veterans Benefits Improvement Act. This is smart stuff. It came out of, and I watched this firsthand last May, traveling with the chairman in New Jersey and Minnesota, listening to veterans, and the case was of let's use this as a force multiplier. Let's use folks who can access this, help get knowledge of the claim, help the VA, be a partner with them to move this further. And this piece of legislation just puts another eye, another help, another way of moving the process forward, and it originated out of the concerns of veterans, and watching the chairman hear that on both sides of the country there, and it was the same exact concern. So I fully support this. I think it's a smart piece of legislation, and with that I yield back, Mr. Chairman.
Thank the gentleman for that. And in the interest of time, we'll forego a round of questions for this first panel. And unless anyone has any questions for this panel, no. Well, on behalf of the subcommittee, I thank you all for your testimony, and you're now excused, and we'll ask the second panel to come to the witness table. With this panel, we will first hear from Jeff Hall, the Assistant National Legislative Director for Disabled American Veterans. Then we will hear from Mr. Raymond Kelly, Director of National Legislative Service for Veterans of Foreign Wars. Next, we will hear from Colonel Robert Norton, Deputy Director of Government Relations for Military Officers Association, on behalf of H.R. 679. And then we will hear from Ms. Heather Ainsley, Vice President of Veterans Policy for Vets First. And finally, we will hear from Mr. Michael Murphy, Executive Director of National Association of County Veterans Services Officers, who will testify on H.R. 733. Thank you all for being here today. And Mr. Hall, you are now recognized for 5 minutes for your testimony.
Thank you. Chairman Runyon, Ranking Member Titus, and members of the subcommittee, DAV is pleased to be here today to offer our views regarding pending legislation before this subcommittee. In the interest of time, my remarks today will be limited to only a few of the bills. As you know, many disabled veterans, their survivors and dependents rely solely on their VA compensation, or DIC, as their only means of income. These men and women should not have to struggle simply to make ends meet because their rightfully earned benefits are not able to keep pace with inflation. Nor should these deserving individuals have to sit in uncertainty from year to year. H.R. 569 would provide a COLA effective December 1st, 2013, while H.R. 570 would provide annual COLAs to be automatic. DAV strongly supports enactment of both of these bills. However, DAV remains adamantly opposed to the section in both of these bills requiring the rounding down of COLA increases to the next lower whole dollar amount. This unfair practice began more than 20 years ago and was only to be a temporary measure. Nonetheless, the practice has continued and has cost veterans and their families millions and millions of dollars of compensation earned through their selfless sacrifice and service to this great nation. Likewise, Mr. Chairman, DAV is steadfastly opposed to the so-called chain CPI, which will not only have an adverse effect on disabled veterans, it will be a double impact on disabled veterans who are also seniors. And reducing the deficit on the backs of our disabled veterans and seniors who have already paid the price is unacceptable. Regarding H.R. 671, the Ruth Moore Act of 2013 would change the standard of proof required and allow service connection for veterans suffering from certain mental health conditions, including PTSD, resulting from military sexual trauma that occurred in service, even in the absence of any official record of the claimed trauma. Enactment of this legislation would allow service connection for certain mental health conditions with a veteran's claim, which a veteran's claim was incurred or aggravated by military sexual trauma in service. Similar to the evidentiary standard for PTSD, the veteran must have a diagnosis of the covered mental health condition together with satisfactory lay or other evidence of such trauma and an opinion by a mental health professional that the diagnosed mental health condition is related to the claimed military sexual trauma, if consistent with the circumstances, conditions, or hardships of such service. As such, Mr. Chairman, DAV strongly supports the enactment of H.R. 671, which would provide a more equitable standard of proof for veterans who suffer from serious mental or physical traumas in environments that make it difficult to establish exact causal connections. H.R. 733, the Access to Veterans Benefits Improvement Act, would provide certain employees of members of Congress and certain employees of state or local governmental agencies with the access to case tracking information in the VA. DAV supports the intent of the bill as it could be beneficial to all parties in the process. However, the bill's current language is not explicit enough to ensure the privacy of a veteran or a claimant is safeguarded. We recommend that the covered employee be required to obtain written consent from the veteran to access his or her records. Additionally, the veteran should be notified when his or her record is being accessed by the covered employee, and the bill should plainly set forth any penalties for such access violations. While DAV would not oppose passage of the legislation, we would urge the subcommittee to consider these suggested language changes. And finally, H.R. 1405 would require the inclusion of an appeals form in the notice of decision, any notice of decision from the VA. DAV supports the intent of this legislation, but we recommend changes to the language to avoid any confusion as to the purpose of the bill or what is intended by the phrases appeals form or a form that may be used to file an appeal. If the intent is to include a standard VBA form to be used by a claimant to submit a notice of disagreement, then it should clearly state such. Otherwise, the intended form may become confused with the standard VA Form 9, Appeal to the Board of Veterans' Appeals, which is currently used by the board and included in a statement of the case after a notice of disagreement has been submitted. It is our understanding that a standardized NOD form has been developed by VBA and is currently at OMB waiting approval. While we don't oppose the creation and use of any standard form directed at simplifying the process, our first concern is always with the claimant. If VBA is going to use a standard NOD form, it must also allow for those instances wherein a claimant will submit their NOD allowed to simply stop in another form, such as a letter. VBA should not be allowed to simply stop accepting NODs if they are not submitted in the prescribed manner. Mr. Chairman, this concludes my testimony. I'll be happy to answer any questions.
Thank you, Mr. Hall. Mr. Kelly.
Mr. Chairman, Ranking Member, members of the committee, on behalf of the 2 million members of the Veterans Foreign Wars and our auxiliary, thank you for the opportunity to testify today on these pending bills. The VFW supports H.R. 569, the Cost of Living Adjustment Act. It is important to veterans and their survivors' compensation keep pace with inflation. However, to do that fairly and effectively, the currently used index, CPIW, must be used in relation to this bill and any future COLA adjustments. Converting to the chain CPI model will come at the expense of the needs of our veterans and their survivors and must be prevented. The VFW also continues to oppose the round down of COLA. This is nothing more than a money-saving gimmick that comes at the expense of our veterans and their survivors. The VFW supports the intent of H.R. 570, placing an automatic trigger to COLA adjustments for DA disability, pension, and survivor benefits will prevent confusion among veterans and survivors who know that VA COLA is somehow tied to Social Security but don't understand the complete process. Using Social Security as that automatic trigger will streamline the process and remove the confusion the current process holds. The only concern the VFW has with this legislation is that there has been strong talk to change Social Security COLA to the chain CPI model. The VFW believes this index undercuts the purchasing power that CPIW provides for those who receive VA compensation. We recommend this bill be amended to maintain CPIW as the index used to calculate VA COLA. The VFW supports H.R. 602. Service members that have sought or may seek treatment for mental health conditions, including TBI, must know that seeking treatment and the possible loss of Second Amendment rights don't go hand in hand. This bill provides an innocent until proven guilty clause by ensuring a judicial authority concludes that the veteran who sought treatment is a danger to themselves or others before the Second Amendment right is revoked. The VFW supports H.R. 671, the Ruth Moore Act, relaxing the evidentiary burden on veterans who have experienced or suffer from military sexual trauma to the same level as combat PTSD only makes sense. We must trust our physicians in determining the root cause of this trauma and then make sure that those suffering from MST find the care and treatment they need. The VFW supports H.R. 679, the Honor America Guard and Reserve Retirement Act. 20 years of service to our country, regardless of when or where one served, should entitle that Garmin or reservist to the moniker veteran. No added benefits will be provided, just the recognition that 2+ decades of service should provide. The VFW supports H.R. 733. The bill would grant certain congressional staff and members of local governmental agency employees access to VA case tracking information. In doing so, this bill will allow Congress to better represent and respond to inquiries from veterans' constituents. The VFW contends, however, that the state and county service officers should only have access to veterans for whom they hold a power of attorney or for veterans who are not represented by a service officer. This will ensure that service officers who hold the POA will be maintained as the primary point of contact for the veterans they represent. The VFW supports the intent of H.R. 894, the Improved to Fiduciaries of Veterans Act. Veterans who need a fiduciary are the most vulnerable of us, and every effort must be made to protect them. Congressman Johnson laid out all the reasons why this is important. However, in trying to remodel this comprehensively at one time, the VFW would like to point out a couple things that we feel like might be an issue. The VFW is concerned that the rewrite to paragraph 5502 of veterans' due process may be violated as the bill stands now. The reason we think this is currently the appointment of the fiduciary is provided for in regulation and not in code. By placing the authority of the appointment on the fiduciary in code, the appointment and due process provisions in regulation will be superseded without the addition of that protection in the statute. The VFW would be happy to work with the committee to ensure the intent of this bill is realized while due process is retained. The VFW also supports the intent of H.R. 1405, However, we recommend that the bill be amended to describe the proposed form as a notice of disagreement and not as an appeals form. This concludes my testimony, and I look forward to any questions the committee may have.
Thank you, Mr. Kelly. And with that, Colonel Norton.
Thank you, Mr. Chairman, Ranking Member Titus, members of the subcommittee. On behalf of the over 380,000 members of the Military Officers Association of America, I am honored to appear before you today. I will limit my remarks to H.R. 679, the Honor America's Guard and Reserve Retirees Act of 2013. The key word in the bill, honor, is the very purpose of this legislation. On Veterans Day, Memorial Day, and other days celebrating our national heritage and honoring all those who served and sacrificed on behalf of our country, there are tens of thousands of career National Guard and Reserve members who cannot stand to be recognized during such ceremonies as veterans of our armed forces. That's because they are not veterans under the law, strange as that may sound. They are not veterans. These are servicemen and women who have completed 20 to 35 years of service in the National Guard or Reserves. They are entitled to a military pension at age 60, government health care, and access to U.S. bases and posts all over the world. They have a military retiree ID card. They are also entitled to certain earned veterans benefits. Those veterans benefits include the Selected Reserve Montgomery GI Bill, VA-backed mortgage loans, service members group life insurance during service, and veterans group life insurance later. And they are entitled to burial in national cemeteries administered by the VA and state veteran cemeteries established under federal dollars. During their careers, many of these career service Guard and Reserve service members performed real-world military missions. But because their duties were performed under non-federal orders, their contributions to the national security at home and overseas don't measure up for award of status as veterans of our armed forces. Only federal active duty orders count for becoming a veteran under the law. During the decades of the Cold War, and continuing in practice today, there are some 29 different types of orders that the Pentagon uses to account for reservists' military duty. That dizzying array of orders reflects the different pay accounts and the types of missions that reservists perform. The truth is that the services prefer to access Guard and Reserve manpower for lots of different kinds of work, but not call them to active duty unless a formal national emergency is invoked. The point is that in many cases, the work performed under those 29 types of orders is in fact operational duty or in support of operations. However, unless an order is issued under Title 10 active duty authority, the mission performed doesn't count for veteran status. Under the law, the VA only accepts a DD-214 as proof of veteran status, except in the unusual case where a reservist is injured or killed while performing inactive duty or active duty for training. The Honor America's Guard and Reserve Retirees Act simply authorizes career reservists who served for decades and performed their duty honorably, but not under a Title 10 duty order, that they be honored as veterans of our armed forces. The bill is cost neutral, and the language specifically prohibits the award of any new or unearned veterans benefits. The Military Coalition has again endorsed the legislation, and its letter of support is in my statement for the record. MOA is very grateful to Congressman Waltz and to you, Mr. Chairman, for your leadership on this issue. The subcommittee, the full House Committee of Veterans Affairs, and the full House have passed similar legislation in the last two sessions of Congress. We look forward to the speedy passage of H.R. 679. I'll close by quoting the letter of a retired New York Army National Guard Master Sergeant who expressed his thoughts on this issue to Military Update syndicated columnist Tom Philpott. And I quote, "I served 35 years as a guardsman, and I am told I am not a veteran. I did 2 weeks at Ground Zero and many tours in Germany doing logistics for the war in Iraq, yet I am still not a veteran. On his behalf and on behalf of tens of thousands of other career Guard and Reserve service members, the Military Officers Association of America strongly urges passage again of H.R. 679. Thank you, Mr. Chairman. I look forward to your questions.
Thank you, Colonel Norton. With that, Ms. Ainsley.
Thank you. Chairman Runyon, Ranking Member Titus, and distinguished members of the subcommittee, thank you for inviting Vets First to share our views regarding the 8 bills that are the subject of this afternoon's hearing. First, we support the Veterans Compensation Cost of Living Adjustment Act and the American Heroes COLA Act. Disabled veterans and their survivors depend on VA benefits to provide for themselves and their families. Cost of living adjustments are an important aspect of ensuring that these benefits are able to meet a beneficiary's basic needs. We urge the passage of both of pieces of these legislation and would also associate ourselves with the comments of our colleagues who have spoken out against using the chain CPI to calculate the cost of living for those benefits. Second, we support the Veterans Second Amendment Protection Act. We believe that this legislation will ensure that a veteran's Second Amendment rights are not unduly limited to a VA's determination that the veteran requires assistant managing his or her benefits. It will also help to ensure that fears about loss of Second Amendment rights are not barriers to treatments for veterans who may have mental health concerns. This legislation would ensure needed judicial protections. Third, we support the Ruth Moore Act. This legislation would ease the burden on military sexual trauma, or MST, survivors in receiving benefits for an MST-related mental health condition, and we also urge swift passage of this critical legislation. Fourth, we associate ourselves with the comments of my colleague, Colonel Norton, in supporting the Honor America's Guard Reserve Retirees Act, and hope that that legislation will again be passed by this body and enacted into law. Fifth, we have concerns about the Access to Veterans Benefits Improvement Act. Although we support the goal of ensuring that veterans receive timely information regarding the status of their claims, we are concerned that providing access to sensitive claimant information without regard to the designation of a power of attorney or written release of information could jeopardize sensitive information. With proper safeguards, the ability to access information through VA's case tracking system could be of great benefit to veterans and those who are assisting them. However, VA must also take increased steps to provide accurate status information to claimants. Next, we would like to offer qualified support for the requirement for VA to include an appeals form in any notice of decision issued in benefits or HR 1405. Specifically, we support this legislation, but propose that the language be clarified to state that VA must provide a form that may be used to file a notice of disagreement with the decision to eliminate any potential confusion with VA's Form 9, the appeal to the Board of Veterans Appeals. The remainder of my remarks will be regarding HR 894. We support legislation to improve the supervision of fiduciaries of VA's beneficiaries, which is again HR 894. We believe that VA's fiduciary program must be veteran-centered and tailored to address the needs of those beneficiaries who truly do need assistance in managing their benefits. This legislation takes important steps to ensuring that VA's fiduciary program has greater transparency. For example, if VA determines that a beneficiary is incompetent, then he or she must be provided with a written statement detailing the reasons for such a determination. We suggest, however, that this provision would be strengthened by addressing the criteria that VA should use in making the determination. We would also suggest that the legislation's use of the term mentally incompetent does not accurately reflect the limits of VA's role, and instead suggest the use of the term financially incompetent. Also included in this legislation are statutory protections to ensure that beneficiaries have the ability to request the removal and replacement of a fiduciary. This legislation also requires that any removal or new appointment of a fiduciary not delay or interrupt the beneficiary's receipt of benefits. While matters of fiduciary appointments are being resolved, veterans must be able to continue to access their benefits. Access to benefits, including retroactive benefits, has remained a problem for too many veterans. We also believe that efforts to strengthen the inquiry and investigation into the qualifications for fiduciaries will ensure a higher level of service for many of our beneficiaries. It will be important, however, to ensure that VA exercises appropriate discretion to ensure that family member fiduciaries are not unduly burdened in complying with requirements. Again, thank you for the opportunity to share our views on each of these bills, and we look forward to answering any questions that you may have today. Thank you.
Thank you, Ms. Ainsley. Mr. Murphy.
Mr. Chairman, members of the committee and staff, it is truly my honor to be here for this hearing. As Executive Director of the National Association of County Veteran Service Officers, I'm here today to comment on the proposed bill H.R. 733 to grant access to Veterans Administration information to governmental veteran service officers. The National Association of County Veteran Service Officers is an organization made up of local government employees. Local government employees that believe that we can help the Department of Veterans Affairs reduce the number of backlogged benefits claims that veterans are currently waiting to have adjudicated by the Department of Veterans Affairs. Our members work in local government offices as an arm of government, if you will, in 37 states, and currently are comprised of 2,400 full-time employees in 700 communities. We're not like a veteran service organization. We're not dues-driven or membership-driven. Every veteran, their dependents, and their survivors who live in our respective jurisdictions are our clients. We serve them at no cost to the client. We're equipped to handle and ready to assist veterans one-on-one with every Department of Veterans Affairs benefit, state and local benefits, and the reason we're here today to assist them in tracking with their claim. There are over 22 million honorably discharged veterans of the Armed Forces of the United States. During the course of their life after the military, they may have occasion to file a benefits claim for pension or compensation. Most veterans are not a member of a veteran service organization, but the chances are that they'll live in one of our communities served by a state, county, or veteran service officer, city veteran service officer. The citizens of our communities, to the citizens of our communities, we are the Veterans Administration. The main issue we're here to talk about today is a lack of cooperation by the Department of Veterans Affairs in recognizing our members as an arm of government. We are treated as if we are a veteran service organization rather than what we are. As governmental employees, we are not unlike the VA itself. There's just a failure to recognize us in that light. Let's say a veteran comes into my office to file a claim for a knee injury that occurred while the veteran was on active duty in the Army. We have to first determine his eligibility on wartime, peacetime service, and a number of factors established by the Veterans Administration. Let's say the veteran appears to be eligible. We then put together a claim for compensation, gather up medical evidence, service medical records, service records, buddy statements, and other pertinent information, and submit the claim to one of a number of veteran service organizations. We help the veteran select a veteran service organization to represent the veteran through the power of attorney. This is done so that the veteran may have representation at the VA regional office for any subsequent appeals that may occur. Our local government veteran service officers may hold the power of attorney, but many are just too far away from the regional office to adequately represent their client. My own office is 305 miles away from the regional office. Then after about 3 months, the veteran comes back into my office and asks what the status of his claim is because he's heard nothing. I have no way to gain this knowledge even though the claim originated in my office. I have to refer him to the VA's 1-800 number and hope that he can ask the right questions, or back to the Veteran Service Organization that holds his power of attorney and who he does not know and probably won't call. Hopefully, he won't go to another jurisdiction and file another claim, which adds to the backlog. What we're asking in this bill under consideration is to allow the government veteran service officers to have read-only access to their clients' information. This will allow local government veteran service officers to properly track, provide follow-up for their clients. Sometimes a veteran will file an appeal on a denied claim and then go to another veteran service officer in another jurisdiction and file another claim for the same thing. This ultimately adds to the backlog and unnecessarily bogs down the system. If enacted, this bill would avoid duplication of claims, which in turn will assist in reducing the backlog of claims. We know there's much consternation on the part of the Veterans Administration regarding this issue. They have had some problems in the past keeping secure that information that veterans must give to the government to obtain the benefits they earn. We understand this and are held to the same standards as the VA already. Remember that the majority of claims for compensation and pension originate in local governmental veteran service officers. We're required to keep secure that information that we are supplied to the veteran service organizations and ultimately to the Veterans Administration. As a prerequisite to receive access to the VA databases, the government employee must be accredited with the Veterans Administration, must have attended and successfully completed training, responsibility, involvement, and preparation of claims or TRIP training, and must have had a background check performed on them as a condition of employment. In closing, the National Association of County Veteran Service Officers recommends that this committee move this bill along in the legislative process. We believe that this bill has the potential to make a significant difference in the lives of returning veterans and will afford them a better opportunity to obtain their earned benefits. Thank you for your time and attention.
Thank you, Mr. Murphy, and thank all of you for your testimony. I wanted to give a special thanks to Colonel Norton. I know he went above and beyond, if you can believe that, having emergency dental surgery yesterday. And not only that, his daughter was in Boston at the marathon. So thank you for doing everything you could to get here to help us move this important legislation.
Thank you, Mr. Chairman. I appreciate that.
With that being said, Mr. Murphy, my first question is for you. Why do you believe the VA is reluctant to grant additional access to county veteran service officers?
I think it's exactly for the reason I stated in the testimony, is that they've had problems with safeguarding this information in the past. I think they received an awful lot of egg on their face over that lost computer or whatever the situation was. It hit the press. It was a bad situation for everybody involved, and we certainly understand that. I mean, it's we are held to the same standards at the county level where I work. With the HIPAA regulations, everything is exactly the same for us as for them. I think that's the main reason they're reluctant in doing it.
Can you talk a little bit about, I know in a federal office, the veteran has to sign a release for us to even start to process their claim. Is it much the same process where you're at?
Exactly, and when they come in, we hold a file on them as our own C file, if you will, and track that claim as best we can, so that we have information readily available to the veteran. Unfortunately, we just can't find out the status of it based on that. So
it's kind of in the same line of questioning to Mr. Hall and Mr. Kelly. I understand the security concerns. How do we avoid them? I mean, obviously, Mr. Murphy has that what he feels the fear of the VA, but and we know there's you have to have clearance to do any of this. How do we make it happen and satisfy what the VA's fear?
When this legislation was, another version of it was in the last Congress, we had recommendations for improving the language of that to allow DAV to be able to support this. We're pleased to say that it has moved along further in the present tense bill, and we don't really have a problem in supporting this particular legislation, or I should say it this way, we can support this legislation provided that those additional security measures that we're asking for are incorporated into that language. Written permission from the veteran to ensure that he or she has given that to that particular service officer to be able to access it. And also...
Do you see an issue with people going out there without the request being made?
Could be. Again, one of our previous concerns and how we phrased it in when the last bill was presented was simply, they don't have to have a power of attorney, and if they have access, I have to have a power of attorney through DAV. I'm an accredited service officer to be able to do that. That gives me the ability to access a system. What we're talking about in a bill, if we're going to allow anybody, any service officer, county service officer in this case that we're referring to access a record, they need to have written permission in the file from the veteran to do so. Would they? Could. There's nothing in the bill that would stop them from doing it, which leads to the second point, which is the bill should contain language or a provision in there that clearly spells out any violations of such access. Now, we're not saying that they're out there just maliciously and every one of them is going to do it. Let's be fair-minded here. We want to ensure that if it does, that it's minimized at the very most, because even as the gentleman to the end has said, you know, there's been incidents in the past. We just want to ensure that a veteran is protected, and we feel that our 3 recommendations that we've included will do that.
And I know everybody kind of commented on our notice of a disagreement of form. Is it the more just how we're titling the form than anything else, Mr. Kelly?
It is. We read it, and I called Mr. Hall, and we both concluded the same thing, that there is a process in place. And it felt like because of the title of it that the process was being diverted. So just changing it to that notice of disagreement at the beginning clarifies that. The process stays the way it is. Nothing else would need to be changed within code or regulation, and veterans would be better served with this bill passing.
Ms. Ainsley, did you want to say something?
I would like to say, I showed the bill to our National Service Director and got the very same question of which appeal form are we talking about? So as people who look at the claims every day, nothing against including a notice of disagreement form, but he just wasn't certain exactly what it was that was being referred to, and he's been doing benefits for a number of years as an attorney. So we just want to make it clear that was our only thing, and I think that would associate with my colleagues.
And again, Mr. Chairman, as our understanding as of this morning, that there is a standardized notice of disagreement form that has been created, developed, and is currently by VBA and is currently over at OMB waiting final approval. That would clearly would say at the top of it, notice of disagreement. And I understand now, upon first reading, as my colleagues have said, upon first reading, I didn't know exactly what form we were talking about, because the only appeal form I know of is a VA Form 9, which is a board form, not a VBA form. And so just a simple clarification of what exactly it is what form we're talking about to be included. And so if it is the standardized notice of disagreement, then that's fine.
Thank you. With that, recognize the ranking member, Ms. Titus.
Thank you very much, Mr. Chairman, and thank all of you for coming. It's very valuable for us to have your wise counsel on these bills as we move forward. I'd like to start by saying that I'm the co-sponsor and a proud co-sponsor of 569 and 570, the American Heroes COLA Act, and I completely agree with those of you who made the statement that we do not want to see this tied to any kind of chained CPI, and that would not be my intent at all, and I would fight against that. Second, the bill that y'all have been talking about is my bill, H.R. 1405, about the request to include the form when you send out a denial for benefits. And I very much appreciate your support, and I look forward to working with you on clearing up that language. We don't want to make it more trouble. We want to make it easier. And in previous hearings, we heard that once you get the denial, you have a certain amount of time to request the form. Then they have a certain amount of time to send you the form, and then you're down the road several months. If you get the form when you get the denial, then you can go forward much more quickly and expeditiously, and that's what our intent was. So thank you for helping us clear that up, and we want to put that language in there that meets those needs. Also, I just want to ask you a kind of a general question. When I was in the Nevada legislature, I had a bill to create the Office of Women's Services in Nevada. Some states have it, some don't. We didn't, even though we had about 30,000 women veterans in the state. And they're often referred to as forgotten veterans because they're less likely to take advantage of benefits, both health care and education, than our men. I'm very supportive of Shelley Pingree's bill before us today about sexual assault, but I wonder if in some of your assistance to veterans groups, you have come across other things that we could do to help with women veterans specifically that you might want to suggest to us. And if not right now, maybe you would think about that and get that information to me.
Thank you, ma'am. If I could, as you suggested, we would like to submit for the record on that. One of my colleagues in our national office has served on the VA Advisory Committee on Women Veterans, and this is a big issue in terms of the cultural development, if you will, the cultural evolution of the VA. I think they're doing a lot more to be welcoming to women veterans, but there's still a lot more to be done. I mean, the face of the VA, frankly, still today looks like guys like me. But we need to be much more receptive to our young women warriors who are coming back from Iraq and Afghanistan, and for women who have served during previous periods of conflict. It's a very important issue, and we would look forward to providing some information to the record on that. Thank you.
Thank you.
I would just say, I don't personally have that in my portfolio at my office, but we do have quite a forward Stand Up for Women Veterans initiative that we've had for several years. And what I'd like to do is take that for the record and go back to our deputy, Joy Elam, who handles that particular matter, and hopefully can provide you some, I'm sure, some suggestions.
Well, I'd appreciate that. And we see if there's anything we can do legislatively, and I'd like to work with the chairman to follow up on some of that. So thank you very much.
I'd like to comment as well.
Sure, please do.
There's three priorities is passing the Ruth Moore Act. Second is outreach to women veterans, to let them know they are veterans, to let them know there is access. I was at the Baltimore VA yesterday for an appointment. As I walked in and checked in, I looked over at the sign to point you to the right room. There's a women's clinic there. I went up to the neurology floor where I needed to be seen, and more than half of the patients in there were female veterans. So women are starting to recognize they have that accessibility. We also need to do training. So when any veteran walks up, that they're treated properly, and specifically women veterans. So there is not the assumption that they're the spouse or the daughter of some other veteran. That training within VA to make sure that folks know that women veterans are coming here, treat them as such.
Thank you. Thank you, Mr. Chairman.
Thank you, Charlie. Ms. Negrete McLeod. Okay. Where'd I go? Well, on behalf of the subcommittee, I want to thank each of you for testimony, and you are all now excused, and I'll ask the third panel to come to the table. On this panel, we will hear from Dave McLennigan, Director of Pension and Fiduciary Services with the U.S. Department of Veteran Affairs. He's accompanied by Marianne Flynn, Deputy Director for Policy and Procedures Compensation Service with the U.S. Department of Veterans Affairs, and Mr. Richard Hippolyte. Mr. McLennigan, you are now recognized for your testimony.
Mr. Chairman and members of the subcommittee, thank you for the opportunity to present VA's views on several bills that are pending before the committee. Joining me today, as you just heard, are Ms. Mary Flynn, an Assistant Director in VA's Compensation Service, and Assistant General Counsel Richard Hippolyte. The issues covered by these bills are important for veterans, and we look forward to working with the subcommittee on these bills. VA strongly supports the bills providing cost of living adjustments to the rates of disability compensation and dependency and indemnity compensation because they tangibly express the nation's gratitude for service-disabled veterans and their survivors. We are also glad to offer our support for H.R. 1405, which would require VA to provide, with notice of each decision on a claim for benefits, a standard form that may be used to appeal the decision. It would simplify the appeal process and improve the timeliness and quality of processing notices of disagreement. H.R. 602 would, in effect, exclude VA determinations of incompetency from the coverage of the Brady Handgun Violence Protection Act restrictions. VA does not support this bill. However, we believe VA provides adequate protection to veterans who cannot manage their own financial affairs under current authority, which allows a beneficiary to reopen the issue of competence or petition VA for relief from the Brady Act restrictions. Mr. Chairman, the Secretary and the Undersecretary for Benefits have a strong interest in ensuring that military sexual trauma receives the attention it deserves in VA. VA is committed to serving veterans by accurately adjudicating claims based on sexual trauma in a thoughtful and sensitive manner, while fully recognizing the unique evidentiary considerations presented by each individual claim. To address those considerations, VA developed policies and procedures intended to assist claimants in developing evidence for these claims and trained its personnel on proper adjudication. As we describe at length in our testimony, our focused training and recognition of the unique evidentiary considerations for each claim has yielded a significant increase in grant rates. Regarding H.R. 671, we do have concerns. Detailed in our testimony about the evidentiary standards in the bill, which could have unintended consequences for the claims process. Because of the progress we have made with these claims under revised procedures, policies, and training, VA prefers to continue pursuing non-legislative actions to address the special nature of claims based on military sexual trauma. H.R. 679 would add a provision to current law to honor as veterans, based on retirement status alone, certain persons who performed service in the reserve components of the armed forces. VA recognizes that the National Guard and reserves have admirably served this country. However, VA does not support this bill because it represents a departure from active service as the foundation for veteran status. H.R. 733 would require VA to provide a covered employee with access to VA's case tracking system to provide a veteran with information regarding the status of his or her claim, regardless of whether the covered employee is acting under a power of attorney executed by the veteran. VA does not support this bill because it would lessen veterans' personal privacy protections while adding a significant administrative burden for VA. VA appreciates the committee's interest in improving the fiduciary program, but finds several provisions of H.R. 894 problematic. Although VA does not support these measures, VA shares the desire to improve the program and has already taken significant steps to address concerns. For example, VA consolidated its fiduciary activities to 6 regionally aligned fiduciary hubs, rewrote all of its fiduciary regulations, implemented a new field examiner training program, and designed a new information technology system for the program. Currently, 92% of the beneficiaries in the program receive services from an unpaid volunteer fiduciary, generally a family member or a friend. However, VA appoints paid fiduciaries in some of its most difficult cases. This bill would reduce fiduciary commissions to 3% of the beneficiary's monthly benefits, or $35, whichever is less. It would also require both paid and volunteer fiduciaries to pay the expense of a surety bond out of the fiduciary's own funds, rather than out of the beneficiary's funds. These provisions would create a strong disincentive for serving vulnerable veterans and their survivors and might significantly impair the program. Among other things, VA is also concerned about provisions that would require it to obtain an annual accounting regarding every beneficiary in the program that has a fiduciary, currently more than 135,000 beneficiaries. VA opposes these provisions because they would burden fiduciaries, again, most of whom are volunteer family members or friends, without significantly improving VA's oversight. Mr. Chairman, this concludes my statement. I'm happy to entertain any questions that the subcommittee may have.
Thank you very much. And with that, I really want to start with the fiduciary program. We had this conversation last year, and you said you intended to take a look at the statutes governing the fiduciary program and make recommendations that might improve it. Do you have any specific examples of any changes you've made to improve it?
You mean separate from statutory matters? Yes, sir. As in addition to the 4 that I've mentioned, actually the system that we've designed is being piloted this summer. One of the most significant flaws we've had is an inadequate IT system for the fiduciary program. So we're actually beyond the point of design. We're building it now, and it'll be piloted this summer. Also, we've issued guidance clarifying that the role of the fiduciary is actually to determine what is in the best interests of a beneficiary, not VA. This is one of the major issues that we discussed at the last hearing we attended. We've issued guidance regarding Fees, specifically whether a fiduciary can take fees out of a retroactive benefit payment, which, as you know, happens in virtually every single case where we award benefits. We've made it clear that that's not appropriate. Rather, fees can only come out of monthly benefits. In addition, we issued guidance to our fiduciary hubs instructing them to advise fiduciaries that they must provide a copy of an approved annual accounting directly to the beneficiary that they serve. Again, to change the culture in the fiduciary program to ensure that fiduciaries are actually acting as fiduciaries. The point being the VA is not the fiduciary. As far as statutory initiatives, as part of the President's budget submission, we have a legislative proposal to provide VA a exemption to the Financial Right to Privacy Act so that we can obtain better information directly from financial institutions where fiduciary accounts are maintained. That's just a sample of some of the things we've done, sir.
I'll go back to the beginning part of the statement. When you're referring to guidance, you're talking about regulation or training letters?
Regulations, sir, have I think as I mentioned in a prior hearing, they've been completely rewritten. The concurrence process in VA is, as of today, almost complete. OMB has a advanced copy of it. I am very hopeful that those regulations will hit the street for public comment very soon. Many of the other things that we have done have been in guidance to our field personnel through what we call fast letters. Those are guidance documents that we issue.
I have another question going back to the COLAs. Can you explain the rationale behind the round-down requirement and any benefits that are derived from its usage?
Well, sir, my knowledge of it is pretty much consistent with the prior panel. Those round-down provisions have been in place for approximately 20 years. It's my understanding that the original intent was to gain savings. However, they've been in place for a long time now. VA does not view the round-down provision in your bills as a reduction in benefits. Rather, it's a continuation of benefits as they've been for a very long time. And VA fully supports your bills as well on that.
Is there any other place that round-down is used for benefits anywhere else?
It's not solely related to the DIC and compensation benefits, but I think I better defer to Mr. Hiplet. He may have an idea of where it might be used in other law.
No, I don't have an example elsewhere, although that's something we certainly could check and provide to the committee as a service if you'd like us to do that.
I would appreciate that. And one last question. You said going back to the fiduciary stuff, you're saying they're being rewritten. Is there a timeline where they're going to be available?
Well, I can tell you this, sir, that under an executive order regarding rulemaking, OMB has 90 days to review a regulation once VA submits it to OMB for review. So I view that as the outer boundary of the time. I know that all the concurrence process within VA is nearly complete based on the information that I have.
With that, I'll recognize the ranking member, Ms. Titus.
Thank you, Mr. Chairman. Thank you all for being here. I understand your comments about 671 and the preference to do it through regulation and within the committee, not through legislation. In a previous hearing, the VA indicated that you would be willing to, or you were offering to rejudicate all previously denied claims that were regarding military sexual trauma. I wondered if you could tell us, kind of give us an update on this, tell us where it is, when it'll be completed, how many cases have been readjudicated.
Ma'am, I'm going to let Ms. Flynn answer that question. She's the expert in this area.
Thank you.
Thank you. Yes, ma'am. Since the hearing on last July, we've actually we're going to do 2 different reviews. One has been completed, And that was a review of a statistically valid sample of MST claims that had been previously denied where an examination was provided. So we sampled approximately 300 claims, and our Nashville Quality Assurance Office conducted a specially focused review on those cases. And the, excuse me, that was at the request of Representative Pingree. We found that the overall accuracy of that focused review was that 86.19% were accurate, and that compares favorably with the current national benefit entitlement accuracy level of 86.31%. With regard to the larger review that you mentioned, we are going to be sending out letters to veterans advising them of the opportunity to request VA review their previously denied MST claims. The steps that we've undertaken to leading up to that have been that we requested and received an opinion from the Office of General Counsel regarding the authority to do a review, the scope of that review, and how to resolve various effective date issues. We've since prepared a letter to the veterans that is scheduled to go out probably at the end of this week. And we expect that a certain percentage of them will request that their claims be reviewed again, at which time we will ensure that they get the proper full development and focused review by our claims adjudicators who've been specially trained in MST claims.
And can you tell me how you determine who gets a letter?
We have in our database, we've done a data pull that links, these will be people who have previously submitted a claim for PTSD based on military sexual trauma. If they were denied, then they'll be sent a letter. Now the caveat is that our database only linked that MST identifier going back to 2009.
Only 2009?
Sorry, it's either 2008 or 2009, but there's definitely going to be a gap in years since the regulation that relaxed the evidentiary standards was put into place in 2002. And so to reach those veterans, we plan to have an outreach process and a notification process advising them of the opportunity to seek review of their claims.
And how will you do that? How, when you talk about outreach, what does that mean?
Well, our Public Affairs Office is working up a communications plan. It involves notifying the stakeholders, getting the word out to the VSOs, as well as the call centers and the Benefits Assistance Office, and enlisting the help of whoever we can to get the word out. In our experience, usually favorable reviews such as this, the word spreads quickly, so we are optimistic that we will reach the targeted audience.
Thank you, Mr. Chairman.
Mr. Negret-McLeod, no questions? I do have another question. Mr. McGladkin, talking about having a standardized appeal form, in your opinion, would such a form have any noticeable impact on the current backlog?
Well, sir, I think it's our position that moving forward, that's exactly the type of thing that VA needs to do. In other words, simplify the benefits programs that we administer by having things like standardized forms. What that leads to is ease in automating and developing rules-based systems for the benefits that we administer. So this is a very good start, and we wholeheartedly support it for that very reason. Whether it would have a measurable impact on the backlog, I can't answer that question. On the other hand, it's a matter that relates directly to appealed cases, so that's not directly related to the backlog of claims that have not been adjudicated finally. But to the extent that there's a backlog of appeals or there's delays in the appeals process because we cannot identify a notice of disagreement, currently a notice of disagreement can be written on anything and given to VA in any format, as long as it's written. that creates problems because we're required by regulation to go out and clarify whether that is an NOD and what the claimant's intent is. So to the extent all of that is removed from the system by having a standardized form, it would be very helpful in the appeal process.
Thank you. With that, no further questions? Well, on behalf of the subcommittee, I want to thank all of you for your testimony. Look forward to working with you often in the future on a wide range of challenges facing our nation's veterans. You are all excused. I ask unanimous consent that all members have 5 legislative days to revise and extend their remarks and include extraneous material. Hearing no objections, so ordered. I thank the members for their attendance today, and this hearing is adjourned.